ensure the widest possible access to documents, to establish rules ensuring the easiest possible exercise of this right, and to promote good administrative practice on access to documents. Article 2. Beneficiaries and scope. Any citizen and any natural or legal person residing or having its registered office in a member state has a right of access to documents of the institutions, subject to principles, conditions, and limits defined in this regulation. The institutions may, subject to the same principles, conditions, and limits, grant access to documents to any natural or legal person not residing or not having its registered office in a member state. Without prejudice to Articles 4 and 9, documents shall be made accessible to the public, either following a written application or directly in an electronic form or through a register. In particular, documents drawn up or received in the course of a legislative procedure shall be made directly accessible in accordance to Article 12. Sensitive documents, as defined in Article 9, Number 1, shall be subject to special treatment in accordance with that article. This regulation shall be without prejudice to rights of public access to documents held by the institutions, which might follow instruments of international law or acts of the institutions implementing them. Article 3. Definitions. For the purpose of this regulation, document shall mean any content, whatever its medium, written on paper or stored in electronic form, or as a sound, visual, or audiovisual recording, concerning a matter relating to the policies, activities, and decisions falling within the institution's sphere of responsibility. Third party shall mean any natural or legal person or any entity outside the institution concerned, including the member states, other community or non-community institutions, and bodies and third countries. Article 4. Expectations. The institutions shall refuse access to documents where disclosure would undermine the protection of the public interests as regards public security, defense and military matters, international relations, the financial, monetary or economic policy of community or member state, privacy and the integrity of the individual, in particular in accordance with community legislation regarding the protection of personal data. The institutions shall refuse access to a document where disclosure would undermine the protection of commercial interests of a natural or legal person, including intellectual property, court proceedings and legal advice, the purpose of inspections, investigations and audits, unless there is an overriding public interest in disclosure. Access to a document drawn up by an institution for internal use or received by an institution which relates to a matter where the decision has not been taken by the institution shall be refused if disclosure of the document would seriously undermine the institution's decision-making process, unless there is an overriding public interest in disclosure. Access to a document containing opinions for internal use as a part of deliberations and preliminary consultations within the institution concerned shall be refused even after the decision has been taken if disclosure of the document would seriously undermine the institution's decision-making process, unless there is an overriding public interest in disclosure. As regards third-party documents, institutions shall consult a third party with a view to assessing whether an exception in paragraph 1 or 2 is applicable, unless it is clear that the document shall or shall not be disclosed. A member state may request the institution not to disclose a document originating from that member state without its prior agreement. If only parts of the requested document are covered by any of the exceptions, the remaining parts of the document shall be released. The exemptions, as laid down in paragraphs 1 to 3, shall only apply for the period during which the protection is justified on the basis of the content of the document. The exceptions may apply for a maximum period of 30 years. In the case of documents covered by the exceptions related to privacy or commercial interest, and in the case of sensitive documents, exceptions may, if necessary, continue to apply after this period. Article 5. Documents in the Member States. Where a Member State receives a request for a document in its possession originating from an institution, unless it is clear that the document shall or shall not be disclosed, the Member State shall consult with the institution concerned in order to take a decision that does not jeopardize the attainment of the objectives of this regulation. The Member States may instead refer the request to the institution. Article 6. Applications. Applications for access to a document shall be made in any written form, including electronic form in one of the languages referred to in Article 314 of the EC Treaty, and in a sufficiently precise manner to enable the institution to identify the document. The applicant is not obliged to share the reasons for the application. If an application is not sufficiently precise, the institution shall ask the applicant to clarify the application and shall assist the applicant in doing so, for example, by providing information on the use of the public registers of documents. In the event of an application relating to a very long document or to a very large number of documents, the institution concerned may confer the applicant informally with a view to finding a fair solution. The institution shall provide information and assistance to citizens on how and where applications for access to documents. Article 7. Processing of initial applications. An application for access to a document shall be handled promptly. An acknowledgement of receipt shall be sent to the applicant. Within 15 working days from registration to the application, the institution shall either grant access to documents requested and provide access in accordance with Article 10, or in a written reply, state the reasons for the total or partial refusal and inform the applicant of his or her right to make a confirmatory application. In the event of a total or partial refusal, the applicant may, within 15 working days of receiving the institution's reply, make a confirmatory application asking the institution to reconsider its position. In exceptional cases, for example, the event of an application relating to a very long document or to a very large number of documents, the time limit provided for in paragraph 1 may be extended by 15 working days, provided that the applicant is notified in advance and that detailed reasons are given. Failure by the institution to reply within the prescribed time limit shall entitle the applicant to make a confirmatory application. Article 8. Processing of confirmatory applications. A confirmatory application shall be handled promptly within 15 working days from registration of such an application. The institution shall either grant access to the document requested and provide access in accordance with Article 10 within that period, or, in a written reply, states the reasons for the total or partial refusal. In the event of a total or partial refusal, the institution shall inform the applicant of the remedies open for him or her, namely, instituting court proceedings against the institution and or making a complaint to the Ombudsman under the conditions laid down in Articles 230 and 195 of the EC Treaty, respectively. In exceptional cases, for example, in the event of an application relating to a very long document or to a very large number of documents, the time limit provided for in paragraph 1 may be extended by 15 working days, provided that the applicant is notified in advance and that detailed reasons are given. Failure by the institution to reply within the prescribed time limit shall be considered as a negative reply and entitle the applicant to institute court proceedings against the institution and or make a complaint to the Ombudsman under the relevant provisions of the EC Treaty. Article 9. Treatment of sensitive documents. Sensitive documents are documents originating from the institutions or the agencies established by them, from member states, third countries, or international organizations, classified as top secret in accordance with the rules of the institution concerned, which protect essential interests of the European Union or one or more of its member states in the areas covered by Article 4, Number 1A, notably public security, defense, and military matters. Applications for access to sensitive documents under the procedures laid down in Article 7 and 8 shall be handled only by those persons who have a right to acquaint themselves with those documents. These persons shall also, without prejudice to Article 11, Number 2, access which references to sensitive documents could be made in the public register. The sensitive documents shall be recorded in the register or released only with the consent of the originator. An institution which decides to refuse access to a sensitive document shall give the reasons for its decision in a manner which does not harm the interests protected in Article 4. Member States shall take appropriate measures to ensure that when handling applications for sensitive documents, the principles in this article and Article 4 are respected. The rules of the institutions concerning sensitive documents shall be made public. The Commission and the Council shall inform the European Parliament regarding sensitive documents in accordance with arrangements agreed between the institutions. Article 10. Access following an application. The applicant shall have access to documents either by consulting them on the spot or by receiving a copy, including, where available, an electronic copy, according to the applicant's preference. The cost of producing and sending copies may be charged to the applicant. This charge shall not exceed the real cost of producing and sending the copies. Consultation on the spot, copies of less than 20 A4 pages, and direct access in electronic form or through the register shall be free of charge. If a document has already been released by the institution concerned and is easily accessible to the applicant, the institution may fulfill its obligation of granting access to documents by informing the applicant how to obtain the requested documents. Documents shall be supplied in an existing version and format, including electronically, or in an alternative format such as braille, large print, or tape, with full regard to the applicant's preference. Article 11. Registers. To make citizens' rights under this regulation effective, each institution shall provide public access to a register of documents. Access to the register should be provided in electronic form. References to documents shall be recorded in the register without delay. For each document, the register shall contain a reference number, including, where applicable, the interinstitutional reference, the subject matter and/or a short description of the content of the document and the date on which it was received or drawn up and recorded in the register. References shall be made in a manner which does not undermine the protection of the interests in Article 4. The institutions shall immediately take the measures necessary to establish a register, which shall be operational by 3 June 2002. Article 12. Direct access in electronic form or through a register. The institutions shall, as far as possible, make documents directly accessible to the public in electronic form or through a register in accordance with the rules of the institution concerned. In particular, legislative documents, that is to say, documents drawn up or received in the course of procedures for the adoption of acts which are legally binding in or for the Member States, should be subject to Articles 4 and 9, be made directly accessible. Where possible, other documents, notably documents relating to the development of policy or strategy, should be made directly accessible. Where direct access is not given through the register shall, as far as possible, indicate where the document is located. publication in the official journal. In addition to the acts referred to in Article 254 number 1 and number 2 of the EC Treaty and the first paragraph of Article 163 of the Euratom Treaty, following the documents shall, subject to Articles 4 and 9 of this regulation, be published in the official German journal. Commission proposals. Common positions adopted by the Council in accordance with the procedures referred to in Articles 251 and 252 of the EC Treaty, and the reasons underlying those common positions, as well as the European Parliament's positions in these procedures. Framework decisions and decisions referred to in Article 34 number 2 of the EU Treaty. Conventions established by the Council in accordance with Article 34 number 2 of the EU Treaty. Conventions signed between Member States on the basis of Article 29493 of the EC Treaty. International agreements conducted by the Community or in accordance with Article 24 of the EU Treaty. As far as possible, the following documents shall be published in the official journal. Initiatives presented to the Council by a Member State pursuant to Article 67 number 1 of the EC Treaty or pursuant to Article 34 number 2 of the EU Treaty. Common positions referred to in Article 34 number 2 of the EU Treaty. Directives other than those referenced to in Article 254 number 1 and number 2 of the EC Treaty. Decisions other than those referred to in Article 254 number 1 of the EC Treaty. Recommendations and opinions. Each institution may, in its rules of procedure, establish which further documents shall be published in the official journal. Article 14. Information. Each institution shall enable the requisite measures to inform the public of the rights they enjoy under this regulation. The Member States shall cooperate with the institutions in providing information to the citizens. Article 15. Administrative practice in the institutions. The institutions shall develop good administrative practices in order to facilitate the exercise of the right of access guaranteed by this regulation. The institutions shall establish an interinstitutional committee to examine past practice, address possible conflicts, and discuss future developments on public access to documents. Article 16. Reproduction of documents. This regulation shall be without prejudice to any existing rules or copyrights which may limit a third party's rights to reproduce or exploit relevant documents. Article 17. Reports. Each institution shall publish annually a report for the preceding year, including the number of cases in which the institution refused to grant access to documents, the reasons for such refusals, and the number of sensitive documents not recorded in the register. At the latest, 31 January 2004, the Commission shall publish a report on the implementation of the principles of this regulation and shall make recommendations, including, if appropriate, proposals for the revision of this regulation and an action program of measures to be taken by the institutions. Article 18. Application measures. Each Each institution shall adapt its rules of procedure to the provisions of this regulation. The adaptations shall take effect from 3 December 2001. Within 6 months of the entry into force of this regulation, the Commission shall examine the conformity of CASA regulation. Concerning the opening to the public of the historical archives of the European Economic Community and the European Atomic Energy Community, with this regulation, in order to ensure the preservation and archiving of documents to the fullest extent possible. Within 6 months of the entry into force of this regulation, the Commission shall examine the conformity of the existing rules on access to documents in this regulation. Article 19. Entry into force. This regulation shall enter into force on the 3rd day following that of its publication in the Official Journal of the European Communities. It shall be applicable from 3 December 2001. This regulation shall be binding in its entirety